feels that there's a requirement. And in the process that you can strengthen yourself mentally and equip with the knowledge. We have been holding webinars. We have done more than 300 webinars as such. This is the part 2 after the break we took from 5th of February for 1 month. And in this series, we have today called upon Yuvraj Narvankar, a young lawyer and who is known for the manner in which he takes things forward. And we keep on discussing about the electronic evidence, which I can say for people like us, that's it's a new fad, the way the evidence has developed with the changing times. Therefore, proving, authenticating, and disproving the electronic evidence under the Indian Evidence Act. What is the legal journey as such, and what is the way of that thing? Therefore, without taking much time, I would request Mr. Yuvraj, since the today's session is with Daksha Legal, a legal platform in Karnataka, who has joined hands with us, and Mr. Basraj is a former member, is a member bar council of Karnataka. And those who have missed our previous webinars can connect us with they can like, share, and subscribe to the YouTube channel of Beyond Law CLC for the previous webinars and the upcoming webinars. Over to you, Mr. Yuvraj.
Thank you, Vikashji. I hope I am audible. And yes, thanks for having me here on this wonderful platform of Beyond Law CLC. Yes, so before I begin, I must tell you that I want to really make today's webinar as practical as possible, because I think the time has come for us to really think more practically towards the digital evidence rather than be theoretical. So, but don't worry, I wouldn't be presuming that you know the basics. We will start from basics and then we will escalate it, and we will go to little advanced discussions, and we will go to forensics. Maybe in last couple of minutes, I'll give you some hands-on experience of how the really cyber forensics, the very basics of it, how it works. Uh, First, let me ask myself few questions, and in fact, I want you to find the answers to those questions as we go along. Now we all know that the 65B certificate is required along with the electronic evidence and all that is required. Suppose in a testamentary suit, I want to pose three questions that just struck me while I was thinking about this webinar. Suppose in a testamentary suit, the person who propounds the will, he wants to file on record certain email communications between the person who died, the testator, and his attorney, just to show that the will has come naturally. There are no tamperings. This has come in the natural course of business. Now if he wants to produce those emails in evidence, would that be an electronic evidence? The answer will be emphatic yes, because it is the electronic evidence, because they are the emails. Question is, can this person, the propounder of the will, can he file the 65B certificate? The answer would be really no, because if you look at section 65B, it is only the person who is in charge of the computer system. He can file the certificate under 65B. Then what do the person do? Because the person who can do this is already died, the testator, he is no more. The another party to this email communication is the lawyer himself, the lawyer of the testator. But he will raise his hands. He will say, sorry, I am bound by the privileged communication. We all are aware, section 126. I am not supposed to divulge anything. I am not going to sign this certificate. So what are the options that the person has got? Otherwise, the court will say, sorry, look at the latest judgment of Supreme Court. I am not accepting your evidence unless you give us 65B certificate. Look at this situation, what the person is supposed to do. Take another example. If I am a police officer, I go to the home of the accused and I confiscate certain materials, maybe CD or a hard drive or something of that sort. Now I want to produce them in the court of law. Can I compel the accused to file a certificate of 65B? The question is very simple, but the answer is very difficult, that I can't, because that will be strictly against the rules of self-incrimination that we all are aware of, Article 20 of our Constitution. We can't compel someone to self-incriminate. So I can't compel. Then what's the way for me to file 65B certificate? How do I go ahead with this situation? Take another example. In a vacation, I want to file a suit on the basis of a registered sale deed. But my registered sale deed is, let's say, lying in Bangalore. I am in Mumbai. So what I do, I ask my friend at Bangalore to just click on a WhatsApp the snapshot of the registered sale deed and send it across. He does it. He takes a registered sale deed. He goes to my office. He takes photographs and he sends it to or he sends it on my WhatsApp. I take a print or I don't take a print. I directly file that mobile in the court, because you all are aware, in fact we will go to that discussion little later, that if you file the electronic evidence or if you file that digital device itself in the court, then Justice Nariman has now said that you don't require 65B certificate. That will go in as a primary evidence. So assume that the mobile on which on my learned friend has sent me the WhatsApp, I directly file that in the court. Now what treatment should the court give it to that mobile? Is it a primary evidence? Should that directly go into the evidence? Or the court should say, sorry mister, where you have a registered sale deed, you can't withhold your best evidence, you have to get that, I am discarding this evidence? Or should I treat it as a secondary evidence under section 63? Now these are some of the questions that in fact they are going to haunt us in the coming future because of a conundrum that has been created by certain decisions. And in fact we are going to try our way out of all this while we discuss. And therefore, to begin with, Flint, let me tell you very frankly that uh, the whole issue is caused because of certain few observations in some of the judgments, and we have ways and means to overcome these problems. Only we need to be little creative, and this is probably is going to be an endeavor today, that how to look at these problems from a practical perspective. Let us begin with very basics, friends. We all know what is a primary evidence. That section 62 tells us that when the document itself is produced for the inspection of the court, we call it a primary evidence. Fine. In fact, before the year 2000, before the IT Act came, we did not have special provisions. We used to prove all the electronic material with the help of primary and secondary evidence under section 62, or secondary evidence as is defined under section 63. We all know there are certain situations in which you can go for leading of secondary evidence, which of course is again given in the chapter. Then came in the year 2000 a provision of section 65A and section 65B. Now this is a very interesting provision. The reason I am calling it as an interesting, if you look at the margin of these two sections, it talks of admissibility of electronic evidence. Friends, we all are aware that the concept of admissibility is different from the concept of relevancy, is different from the concept of probative value. I am not going into those basics, that there are three different concepts. For example, just to give you a basic example for my friends who have just joined, or probably for the friends who are doing law, suppose if I want to produce in the court of law my communication with my client, that is relevant, but that is inadmissible. Okay, that's privileged communication. If I want to produce on record the communication my client had with his father, that may be admissible, but that is irrelevant. So basically, relevance and admissibility are two completely different concepts. Section 65A and 65B, which were brought into effect by virtue of IT Act of 2000, only talks of admissibility, mind you. And these are going to have some repercussions on the discussion that we are going to have. So please remember, we are going to talk on the admissibility. If you just to tell you the chronology of any electronic evidence, the life cycle is like this. If you look at section 136 of Indian Evidence Act, it talks of relevancy. It says that the judge has power to admit into evidence something which he feels is relevant to the dispute. So the court has, and so before admissibility comes relevancy, technically speaking. In the practical parlance, the things are not like that in the court. Court might say, let me first admit the evidence and then we will go into relevancy. But if you look at the scheme of the Indian Evidence Act, section 136 says that before admitting that, the court may look into the relevancy. So the scheme is like this. Section 136 will tell us what is relevant for electronic evidence. Then we go to section 65A and 65B for admissibility of electronic evidence, the topic that we are going to discuss maybe in a couple of minutes. And then comes, if there is any issue about the genuineness of that electronic record. If the defendant or if the opponent raises some issue about the genuineness of that electronic record, then we have to go to section 22A of the Indian Evidence Act. And we are going to, so basically the thing is like the 136, 65A, 65B, and then we go, if necessary, we go to section 22A. Now let us begin with 65A. 65A is interesting, I said, because if you look at 65A, it says that electronic evidence may be proved in accordance with 65B. We all are taught in the lot. I'm sorry. I just received the comment not audible. Am I audible? Is it fine? Yeah. Okay. Uh, so basically, it says electronic evidence may be proved. Any one of you who has got the Bear Act, I would request you to just hold the Bear Act. It says may. Now the word may indicates that this is merely an enabling provision. Law does not mandate that if the electronic evidence has to be proved, it has to be proved this way. And therefore may word can be interpreted to mean that this is merely an option. It is not a compulsion. But we will go there in little bit in the next 10 minutes that the Supreme Court has now negated this view. But just note the word may. It is going to be of some relevance in the time to come. Then comes section 65b. 65b, friends, begins with the clause notwithstanding. This is an important clause which is going to retain us for next 10 minutes. Let me tell you. The notwithstanding is the clause in 65b which has given birth, I would say, to four judgments, four very crucial judgments that we are going to discuss in next 10 minutes, and then we are going to go ahead. The first judgment you had on this clause was Navjot Sandhu's judgment, which, if you remember, was in way back in the year 2005. Then the next you had was PV Anwar's judgment, which you got in the year 2014. Then you had the Shafi Mohammed case 2017, followed by the latest one, which is Arjun Panditrao Khotkar, which we got in the last few months of 2020. Now, how notwithstanding gave birth to these four judgments? See, the earlier view in Navjot Sandhu's case was the Supreme Court said that, look here, 65A is an enabling provision. It uses the word may. The party may go to 65A and B for electronic evidence. Party may choose not to go for it. If the party so wants, party can lead the regular primary and secondary evidence as it was being done pre-2000 era, and therefore it is merely an enabling provision. This was the view that was taken in Navjot Sandhu's case. Friends, this view held the field for 11 long years till it was overruled by the court in PV Anwar in the year 2014. In PV Anwar, the Supreme Court said, sorry, don't read word may, read the word notwithstanding. This clause gives overriding effect to 65A and 65B. Out goes section 62, 63, 64. What remains is only 65A and 65B. You cannot prove any electronic evidence unless you comply with 65B. And therefore, the view that was there good for 11 years completely gone away. Then came another interesting judgment of Shafi Mohammed. That came, I think, in the year 2017. Shafi Mohammed Supreme Court said ki it's fine that you have to have 65B. But what about a situation where the person who is not in charge of the device has to submit an electronic evidence? Suppose if I print something from the mobile of my wife and I put that in the court, can I vouch for something that is printed from a mobile of my wife? Obviously not. She is the person who is in charge of the mobile, in charge of the device, in charge of the system. So the court says that if the person who is going to put that certificate is not in the management of the device, then in those situations, relaxation can be given, some leniency can be shown, and someone can be relieved of the burden of 65B. This is what the judgment of the Honorable Apex Court in Shafi Mohammed said. And they did all this in the garb of clarification of PV Anwar, let me tell you. Then came the recent judgment of Justice Nariman of three judges bench, which was a reference basically. And that was in the case of Arjun Panditrao Khotkar, where the Supreme Court said this is not done. Shafi Mohammed could not have, in the garb of clarification, cannot negate the ratio of PV Anwar. One thing is clear that 65A and 65B is a complete code. You cannot even look at primary and secondary evidence. And the Supreme Court says is if it's your problem that how to get that person who is in management of the device, look here, we are giving you the list of sections. We are giving you the list of provisions whereby you can summon that person for 65B certificate. So your problem is solved. So the Shafi Mohammed was overruled. So friends, we first got Navjot Sandhu, followed by we got PV Anwar, then Shafi Mohammed, and finally, friends, we got this Arjun Khotkar. The reason I said notwithstanding is so crucial because it's on the notwithstanding that we have got a lot of jurisprudence coming in. Now, after notwithstanding, look at the words. Any information, I'm not really going by section, but you can have a look at the section. Any information contained in an electronic record, printed on a paper or copied, stored, or recorded in optical or magnetic media. Now let's pause here for a moment. And friends, we are going to, in fact, dissect the section this way. I'm going to read out something, I'm going to pause, I'm going to explain, and then we are going to go ahead. Because today I want to discuss not only proving, but I want to discuss disproving of the electronic evidence. And the devil lies in the details. So I want to dissect each word. Any information contained in an electronic record, printed on a paper, it's understandable. Email, I print, fine. Or stored, copied, recorded in optical or magnetic media. Okay, these are two devices, basically, like a hard drive you have, magnetic, or you have CD or DVD, that's called optical. So it may be either on the paper or on hard drive or on uh, CD, DVD. Let me tell you just an interesting on a side note that there are few people who say, technical people, that pen drive is neither of this. Of course, pen drive is not a paper, pen drive is not optical, pen drive is not magnetic. So pen drive is technically pen drive or memory card. You know, the flash memories that we have on our mobile, that is not a magnetic or optical media. So if technically looking at it, one may argue that pen drive, if you want to submit, or a memory card, you are not bound by 65B, because 65B is applicable only for paper, optical, and magnetic. But I think that's not the interpretation, because if you look at the mischief rule of interpretation, a very well known, because in golden you look at what the legislature had said, and in mischief you look at what the legislature meant. Now if you look at what legislature meant, legislature really wanted to include all kinds of electronic records. So I think that's not the ideal way of looking at it. But on a side note, you all must remember that solid state drive, like a flash drive or pen drive, is not within the scope, technically speaking, of 65B. Fine. So printed on a paper and so and so, it shall be deemed to be a document. The next words in 65B is it shall be deemed to be a document. Now this is what we call as a deeming provision. Now why do we require a deeming provision? Because if you look at Indian Evidence Act, word document has not been amended. Like the word evidence is amended, the word document is not amended, and therefore the law has to create this deeming fiction in this section, that if there is an electronic record, it shall be deemed to be a document. But when? Only if you comply with the conditions which are mentioned in this section. There are 4 technical conditions and 1 non-technical condition. What do I mean by technical? What do I mean by non-technical? We will see in a while. So it will be deemed to be a document on compliance of conditions mentioned in this section, and it shall be admissible in the evidence without production of the original. Please understand, please mind these words. It shall be admissible into evidence without production of the original. So therefore, the Justice Nariman has now said that if you bring the original device itself in the court, then 65B is not necessary. But if you can't bring the original server, original computer, original mobile to the court, then yes, you have to comply with these conditions. Okay. And what? It shall be admissible into evidence. Again, not the contents. It shall be admissible as contents of, as a proof of contents of the original. Okay. So if you comply with these conditions of 65B, it is considered to be proof of contents. Okay. Please mind, it is not the proof of veracity of contents. These two are again different concepts. There is a very good judgment of Jaimin Jewelry Exports. I will, in fact, let me tell you that I will be uh, circulating maybe the relevant judgments with the organizers, so I don't bother you with writing the citations. The very beautiful judgment in Jaimin Jewelry, the Supreme Court, the High Court had said that look here, if you comply with 65B, it is merely a it's evidence of the contents. It's not evidence of veracity of the contents. And just to give an example to the students, suppose if someone A sends B an email calling B as a fraud person, B goes to the court, files a suit for defamation. B wants to put that email in the evidence, and B files 65B certificate. Now, filing of this 65B will only prove that yes, A had indeed sent that email to B. It will not prove that B is actually a fraud person. Okay, so it's merely the proof of contents. It's not the proof of veracity of the contents. That has to be independently proved. And in fact, as I told you, Jaimin Jewelry, there is a very beautiful judgment of Om Prakash Barlia of Bombay High Court. Om Prakash Barlia, that's I think 1983 judgment, where the courts have very beautifully distinguished between the proof of contents and between proof of veracity of the contents. Okay, fine. So we got this, that notwithstanding so and so, any information contained in an electronic record, printed on a paper, stored, recorded, copied in optical or magnetic media, shall be admissible on following conditions without production of the original as a proof of contents. Fine. Which are these conditions? There are four conditions. And here our journey into disproving begins. Unfortunately, friends, in India, we in 65B, lot many people keep on asking, tell me the format of 65B, share the format. And that's the most unfortunate part. There cannot be a set format of 65B. And here we have went really wrong. Because without application of mind, we are drafting 65B 1. And as lawyers, we need to really look into what 65B says rather than taking it at its face value. I'll explain this. Which are these four conditions? Just kindly have a look at these four conditions and I'll make my point. The first condition that you will find in section 65B(2), the first condition, the computer output is produced during the period when the computer is used regularly for the purposes of any activities regularly carried on by the person having lawful control. Okay, so you get four things: that the computer output is produced during the period when computer is used regularly, one, for the purposes of activities regularly carried on, second, and thirdly by the person having lawful control. Okay, take an example of a CCTV. Okay, I'll give an illustration so you understand this. Suppose there is a Prevention of Corruption Act case, and in a mall in a city, that government officer is going to come to accept that amount of a bribe. Now the police machinery wants to capture this in a CCTV footage as a proof. They, now what happens, they take the CCTV, they put that before forensic laboratory, they file that in the court with charge sheet. Now tell me, suppose if that CCTV in the mall was not working just a day prior to, it was not working, the police came there, they laid a trap, and they made sure that CCTV is now working. Can we say that that computer was being used regularly? The answer is no. That is not the case. One. Take another case. In the same illustration, that CCTV has to have a DVR for recording the footage. You know, every CCTV comes with a DVR. Either it has to have a hard drive or it has to have the memory card. So it has to be stored somewhere. Assume a case that that day that CCTV does not have any DVR, does not have a memory card. Okay. So what the police do, they run to the counter, billing counter, and they say, give me some memory card or give me something to store. I need the CCTV, otherwise is not functional. So the cashier there gives him the memory card of the billing desk and gives it for CCTV recording. Fine. And they record the footage on that. Now look at the condition. Can we say that that device was being used for the purposes of activities regularly carried on? Technically, the answer is no. The regular activity of that memory card is not storage of the video footage, it is the storage of the data, that billing data. So, technically, even the second condition goes out of place. Take a third scenario. I am the private person who has filed that prevention of complaint case, and I wanted the police to lay a trap. Fine. The police is not cooperating. To make the trap good, to make the trap stronger, so what I do, I am a software engineer, I hack into the CCTV machine and I make sure that angle of CCTV is exactly on that government servant who is standing there to take a bribe. I have hacked into the system, or I go and I bribe that cashier or the IT manager and say, boss ki, just make that CCTV focus on that guy. Tell me one thing, if I am the one who is running that machine, if I am the one who is hacking into that machine, can I be said to be the person having lawful control over the device? Answer is no. So in a same case, in a CCTV case, a classic CCTV example, the first condition fall foul of. We did not have the computer being used regularly. We did not have the memory card, so it was not being used for the activities regularly carried on. And thirdly, it was by the person who did not have any lawful control over it. And that's how you have to really look at section 65B certificate. Because what we do, Because of the language of 65B, we are so blinded. Otherwise, the peripheral vision of the lawyers is awesome. But because of the language of technical language, we just take every 65B at its face value. Look at the second condition, and will try to decode this. If you look at the second condition, it says the computer output as derived. Please look into the words. Computer output is derived was regularly fed into the computer in the ordinary course of the business. Fine. It is derived uh, when it was regularly fed into the computer in the ordinary course of business. In Classic Evidence Act, we have called is a res geschi. You probably have heard this in the ordinary course of business. Okay, there is a sanctity, and you will find a similar concept in section 32 of the Evidence Act as well, in the ordinary course of business. Look here, the legislature has given undue importance to the regularity of the input rather than correctness of the input. I'll explain this. Take a case of an electronic weight scale. Okay, you have joined some diet program and he has assured you to lose 20 kgs in a month. You take an electronic weight scale, not the old wala, the new one, electronic weight scale. You stand there every day and you take a, maybe if it gives you some cheat, or if you make a manually note of it, whatever, or it records somewhere in the memory card. You stand there, your weight is 70 kgs. You next day you go there, it is 72 kgs. You do it regularly for a month. Okay, you regularly you are doing it as contemplated by clause B. The data was regularly fed into the computer. Fine. Okay. And now you want to produce that in the court of law. Maybe the claim of them that you would lose the weight has gone wrong, so you want to sue them and you want to produce this as a proof. Now imagine, suppose if I, without you knowing, has increased the basic scale from 0 to 5 kgs. Okay, I can do that. I can make the initial value not as a 0, but I'll make it 5 kgs. What will happen? If your weight is 70, it will show as 75. If your weight is 80, it will show as 85, because I have increased the initial value itself by 5. So it will go on showing those values. Now look here. The law insists on what? Regularity of the input. Is the input regular? It is absolutely regular. Every day I have stood on the machine. Every day I have taken the prints. But still, is the data incorrect? It is absolutely incorrect, because the law unreasonably insists on regularity of the input, not on the correctness of the input. So always remember, whenever you look at 65B certificate, you must look it into the regularity aspect one and the correctness aspect second, which is most crucial. And this is not an hypothetical example that I told you. In USA, this case actually happened, where there is a breath analyzer. When you're driving rash, then the police will come in and they'll ask you to blow a breath analyzer machine, and it will show the alcohol level in your blood. In one of the cases, the accused said that, my lords, I was not really drunk, and there is some problem with the machine. I was not really drunk. Court ordered an investigation into that, and to its surprise, the court found that the initial value of that breath analyzer was set to some high figure. So therefore, had the result been 10, it was showing 15. If it was 15, actually it was showing 20. And there the court found, it's a very beautiful judgment. I'll again circulate the citation, that if the initial input is itself incorrect, the output is bound to be incorrect. And friends, in technology law, this concept is called as garbage in, garbage out. अगर आप garbage डाल रहे हो उसमें, then what you are going to get out is the garbage. Therefore, garbage in and garbage out. Unfortunately, our law has made it garbage in and gospel out. What goes in may be defective, but what comes out is perfectly legal. So I think we should change that approach, maybe in the trial, in the course of the trials. Let us look at the third condition. Throughout the material part of the said period, the computer was operating properly. You have to say this in 65B, that throughout the part of the period, the computer was operating properly. You may feel that this is okay, this is a formal clause, but let me tell you, in recently one of my arbitration cases, how this clause becomes really important. Now, of course, the Evidence Act is not applicable to arbitration, but just to give you an illustration how this clause can assume importance. We have the MFP printers, the multifunction printers, which print, scan, Xerox, copy, and all that. They are called MFPs. In case of printers, if there is a replacement of DVD hard drive, then the page count on those machines, on those printers is reset to 0. For example, if this is my HP printer, if it has printed 5 lakhs pages till date, okay, and I want to prove that this printer has pages 5 lakhs pages till date, okay, but if yesterday, if there was any replacement in the drive, or if there was any problem with this machine, then the page count becomes 0, and therefore now it will not show 5 lakhs, it will show 10, 15, 20, whichever pages I have printed today, it will only show that. And therefore now you will understand the importance of this clause C. Throughout the material part of the said period, the computer was operating properly. Okay, this is clause C. Clause D, I would not retain you for longer because it's actually the most of it is a replica of clause B. There are very few technical differences which are not of really much relevance today. So the point is that you have to have these four conditions in place, which I call as a technical conditions. And as a lawyer, as a trial lawyer, we should be able to decode a certificate of 65B by going into the nuances of this certificate. Now, what is that one non-technical requirement which I spoken about? That is filing of a certificate. This certificate, friends, you would get in section 65 capital B subsection 4, the certificate that you have to file to prove this electronic evidence. Now, let us look at that certificate. Again, there are very interesting points. The certificate has to say three things. First, the certificate has to identify the electronic record. What is that record? If it's a printout, it's a CD, it's DVD, fine. The certificate has to identify that. If it's a CD, you have to say that the make of the CD is this much, this is the memory, this is the capacity, this is what I have done to secure it, XYZ. Second, the certificate has to identify the particulars of the devices involved in the production of the record. Please mind these words. I'll repeat. The certificate has to literally give the particulars of devices involved in the production of the electronic record. I'll tell you the practical significance of this. Take a same case of CCTV in the mall. That CCTV has captured that bribery footage. Fine. Then what did the police do? They took the DVR, they transferred that footage into their own laptop. Fine. They took it to police station. They registered in that register that they seized this, right? It's a property. They send it to forensic lab on a CD. Forensic lab will analyze it on some different CD, so the original footage remain intact. Forensic lab gives a report and sends that CD to public prosecutor with the report. Public prosecutor will make another CD of it, you know, on his own laptop, because they have to give it to the accused under section 2077 of CRPC. Now imagine how many devices are involved in the production of this electronic record. Generally, what we do, we just look at the last device involved in the production of the electronic record, from where the print has come, which machine has made the CD, who has made its copy. That is not the only aspect. You have to look at it from the beginning, that who is the person who was in charge of the CCTV. See, the point is this: 65B certificate is required, no doubt, admitted. But can the forensic analyst give a certificate of the CCTV which is installed in the mall? Can it vouch for its correctness? Answer is obviously no. If the public prosecutor is making copies of that CD or footage, can he vouch for what happened in the cyber forensic laboratory? Obviously not. It is the CCTV IT department, the IT department of the mall alone, which can vouch for the correctness of the footage. One, it is the only cyber forensic laboratory which can vouch for the correctness of the entries, whatever happened in the within the walls of the forensic lab. And it is the public prosecutor's office alone which can vouch for the correctness of the copies which are made. So remember, this is what we call as a concept of contemporaneous certification. The contemporaneous certification means that there can be multiple certificates. In fact, I might use the word not there can be, there are ideally there have to be multiple certificates for a single piece of electronic evidence to make it admissible. And in fact, this concept is very beautifully mentioned by the judgment of Madhya Pradesh High Court in the case of Kamal Patel. Again, as I told you, I'll give that citation, I'll circulate. It's a very beautifully written judgment of Kamal Patel of MP High Court, where the High Court had said that, look here, It's not only one certificate. At each point of time, the electronic record has changed the hands, and therefore at each point of time there has to be a separate certificate. And in fact, in the technical law, we call it as a concept of chain of custody. Chain of custody, there are several chains: procurement, acquisition, storage, analysis, forensic analysis, preparation of a report, and submission in the court. This is the life cycle of an electronic evidence. So at each of these stages you have to have a different certificate. This is what we call as a chain of custody concept. Okay, then second we completed particulars of the devices involved in the production. The third one is that dealing with any of the matters which section 65b2 relates to. That's, I think it's very easy to understand. The four technical conditions that we spoke about, then the certificate can deal with those conditions if they are applicable. Now mind you, little digression but important. Justice Nariman in the recent judgment of Arjun Khotkar had said, if you look at section 65b4, it says certificate doing any of the following will do. Any of the following means it can deal with A, or it can deal with B, or it can deal with C. But Justice Nariman has said no, sorry, it means all of the following. So in fact, your certificate has to deal with all these three aspects. So my advice will be not to fall foul of this judgment. Make sure that even if your yours is a case which does not really warrant dealing with all these conditions, it is better that you specifically mention this. For example, I'll give you an example. Suppose there is a virus attack on my mobile or my laptop. I suffer certain damages. I want to claim a compensation. I go to the court and I say that, look, on this and this day, there was a virus attack on my computer. There was a malware attack. Fine. Now tell me, am I going to say that this data was regularly fed into my system? Obviously not. This was not a regular thing. This was out of blue moon. On sudden day, there was an attack. So technically, this condition does not really apply to me. A data being regularly fed. Okay, this is once in a blue moon attack on my laptop. But it is better that in the light of Arjun Pandit Rao's ratio, that you specifically mention as to why this condition does not apply to you. And then you say this out in the 65B certificate. Okay. Then who has to sign this certificate? And let me, as I told you, I am not going to give you the formats. There are judgments of Arc Shipping Corporation. If you wish, I'll share the citations as well, where the high courts in some judgments have reproduced the certificates. But I would not call them an ideal certificate. I think the ideal certificate is the one that you make for your own case, which is a customized one. Okay. And we will see maybe in a couple of minutes how to make an ideal one for different kinds of electronic evidences. Then who has to sign it? Again, the interesting discussion comes up. It has to be signed by the person who is in an official position in relation to the operation of the relevant device or management of the relevant activities. So it has to be signed by the person who occupies a responsible official position. Okay. Here comes the logic of Shafi Muhammad. If you remember, I told you that what if you don't get the person who is in official position? And there Arjun Khotkar courts have said, look at 4-5 sections. I'll tell you which of them. The first one, the Supreme Court had said section 165 of the Evidence Act. That section gives right, unfettered right to the court to order production of any document or thing. So the Supreme Court has said, look here, you have a section to call that person. I'll give you an example. Suppose if I purchase certain medicals from a medical shop, certain medicines from a medical shop, that medical shop wala gives me a computer printout. Fine. Now I want to, let's say, file a case of a deficiency in services, maybe for whatever reasons. I want to put that medical bill into the evidence. Can I compel that medical shop owner to get him to give me the 65B certificate? Because I can't give, it is his system. It has to be the person responsible for that device. I am not the person. So and in Shafi Mohd, the court had said in such cases, forget it, don't do it. In Arjun Khotkar, the court says, no, look at section 165. You can do that. So that's one section. You can call him to the court. You can compel him to give 65B certificate. One. Second provision the court had said, order 16 rule 6 of CPC. That also gives you another right to call any person or summon any person to produce a document. That's again very interesting provision. Third provision, friends, you would find in section 91 of CRPC. which all of you would be aware of, a summons to produce a document or a thing. That's section 91. And finally, you have section 311, where the courts have got 311 of CRPC I'm talking of, where the courts have got ample powers to summon any witness or examine any person at any stage. That's the beauty of it. At any stage, it can be done. Okay. So the Supreme Court has said that look at these conditions, you can call the person and you can get 65B. Now, this certificate has to be to the base of knowledge and belief. Look at the section again. Please look at 65B4. The certificate has to be to the base of knowledge and belief. Now, it can be either knowledge or it can be belief. This is what Justice Nariman has also said. It can't be knowledge and belief. I'll tell you how. Suppose you are the person who wants to adduce that CCTV into the court. Okay. You are, let's say, public prosecutor's office. You want to produce that certificate in the court. Can you vouch for the correctness of CCTV system? You can't. So you can say, in my belief, I believe that that system was working regularly. Okay. That's to the belief. But when it comes to PP office computer, you can't say it on belief. You have to say, in my knowledge, these copies were made perfectly without there being any tampering. So for the machines which are not within your possession or power, you say to the best of my belief. For the machines which are within your knowledge and capacity, you say to the best of my knowledge. And therefore, Justice Nariman says very rightly, very aptly, that it can't be both knowledge and belief. Either it has to be knowledge or it has to be belief. Okay. One. Now I think let us complete the circle where we started. The testamentary petition, you remember, where it is not possible, or an accused, he can't be compelled because of self-incrimination, rule against self-incrimination. What happens in these cases? Now, in one of the paragraphs, and rather two paragraphs, I think that's para 49 of the judgment, Justice Nariman has said, if there is an impossibility of procurement, if it is impossible for you to procure, then you can be relieved of the obligation of producing 65B certificate. I think, and that was the window I was talking to you about. This small window has been left open. Now there can be a really a discussion whether this is the dictate under Article 142 of the Constitution. I think, if you are all aware of that, to do the complete justice between the parties, the Supreme Court can, in certain situation, can expand the law or go beyond the law to do the justice. But in my humble submission, that's not pronouncement under Article 142. I think it can be used as a precedent, because the Supreme Court in Arjun Pandit Rao has given a detailed discussion of the proposition that law does not compel someone to do the impossible. And so the Supreme Court has said that if it is impossible for you to procure, then you can be relieved of an obligation to get that certificate. But I think, mind you, I think there is a major caveat here, that the practitioners who are going to use this impossibility defense, they have to really, really show that how it is impossible. And I think there are very few situations where it is impossible. Fine. So I think this is very important. Then the question that is I normally ask, then under what section do you prove that document? I think 136 has got wide powers, has given wide powers for the court to admit into evidence anything which it feels relevant. That should not be a problem. Then the point that we are talking about, disproving, how do we disprove? So I would strongly urge all of you to read a very beautiful judgment of Justice Murlidhar in the case of Dharambir versus CBI. It's a Delhi High Court judgment, where Justice Murlidhar had said that the accused has got every right to get a mirror copy of the hard drive. Now, what is a mirror copy? Mirror copy means a copy bit by bit. Okay, you entire replica has to be given to you. Suppose there are 100 calls, okay, recorded by the police. Police cannot say that, look here, your calls are hardly 3 or 4 out of these 100. We are going to give you only 3 4 calls ka recording. You are not entitled for 100. That's not what is called as a mirror copy. Justice Murlidhar has said that you are entitled for a mirror copy of it. And why do you need a mirror copy? It is required for a forensic analysis. Okay, and how forensic analysis we need it, we will see in couple of minutes. Uh, Next 15-20 minutes, we will see why the forensic. This is also called as a forensic copy. So it is the right of the accused to get a mirror copy. Now, is it not true also for a civil trial? I think, of course, yes. If it is coming with the plaint, he has to have the copy, entire copy of the hard drive, the mirror copy. If it is not annexed to the plaint, you have a right of discovery under our order 11, I think you are again entitled for the mirror copy. Now let us talk of at what stage do you submit this. 65B, now it's a settled position, can be submitted at any time when you want to read that electronic record in the evidence. I'll give you an example. Is it required at a charge sheet level? No, it is not required at a charge sheet level. It can be produced subsequently. This is what the Supreme Court has now said. There are so many judgments. There are Sonu versus State of Haryana. Then there is this MR Hiremat versus State of Karnataka, and it is the Arjun Pandit Rao. The Supreme Court has said that it is required only when the document is getting admitted into evidence. In the context of a civil trial, for example, if in a plaint I annex a email, do I need 65B along with the plaint? Of course not. When I want to get that document marked, that time, yes, I will have to have 65B certificate. No, so that's a settled position that you have to have it when you want to get that admitted into evidence. At what stage do we raise an objection that there is no compliance of 65B or 65B is defective one? Now, this is a crucial question, because if you don't do that at the right time, then that objection is considered to be waived. And this is what again a very good judgment. Most Bombay lawyers would know it is the Hemendra Rasiklal Ghia judgment, a full bench of Bombay High Court. Hemendra Rasiklal Ghia, where the High Court, relying on certain very good Supreme Court judgments, has bifurcated the objections in three categories. The objections pertaining to deficit stamp duty, one category. The objections pertaining to mode and manner of a proof of a document, second category. And third category, the document which is inherently inadmissible. It can't be read into evidence at all. And the High Court, the full bench, had said that the first category, where it relates to stamp duty, the objection has to be taken as and when the document is tendered into evidence. You have to take it immediately. So it can be impounded. You know the procedure. When it comes to second category, mode and manner of proof, where 65B will fall, the High Court has said you have to take that objection immediately after that evidence is sought to be marked. If you don't do that, then there are judgments, probably again I will give you the citations, which have said that in the appellate stage, you can't say, look here, my lords, there was no 65B and all that. The court will say, sorry, the bus is gone. You had the right, you had the chance, you did not avail it, it's now waived. And of course, the last category, it's void the ab initio, inherently inadmissible. For example, the privileged communications. I think again, they can be raised at any point of time. There is no requirement that you have to raise it then and there. So the High Court has said the third category objection can be raised at any point of time. Now, whether 65B would be required in family matters, my take on that, and there are some judgments that which say that no, it is not required in family matters, because section 14 of the Family Courts Act relieves you from these obligations, and that gives some leeway. So I think the technical compliance with 65B would not be required in family matters, because in most of the cases you will find that there is an allegation of adultery and all. The husband will get the maybe he will access the wife's mobile and he will get something, and then the question will come of 65B. So no technical compliance is required in family matters. Then in arbitration law, again there is no requirement, because all section 19 of the Arbitration Act uh, clearly says that CPC and Evidence Act would not be applicable. So again, in arbitration, I think 65B wouldn't be required technically. In Motor Vehicles Act, yes, there are also judgment of the Bombay High Court, a famous one, Pushpa Rana judgment, where the Bombay High Court has said in Motor Vehicles Act also it is required. Uh, I know there are certain problems which people are discussing, that suppose if a claimant in an injury case, if he has taken treatment in 20 hospitals, or if he has taken medicines from 20 medical outlets, and they're all computer printouts, then is it required that he has to give 60, he has to get 65B for each of the bill? Unfortunately, the answer is today yes. But let me tell you, there is a very beautiful judgment which will again circulate of the Supreme Court, which has said that Motor Vehicles Act being a beneficial welfare legislation, strict canons of procedure should not hinder the way of the claimants. That's what the Supreme Court has said. So I think there is some possibility of we saying that this can be excused in certain cases. But in by and large, in almost all the cases, today as the law stands, you would require 65B certificate. Now probably I would ask the permission to share my screen, and I'll show how some of the tools, or how can we make the evidence really look good when we go for 65B certificate. uh, I'll first in fact show you what the, I don't know how many of you have heard about hash value. I'll try to show how the hash values are calculated, but before I show you, I'll tell you what it is. Suppose uh, that CCTV example, I'll not really change the example, so that's, since that has been now being there for last 1 hour. CCTV footage is acquired, right, in Mumbai Central, and now it has to be it has to go to police station, then forensic lab, then PP's office, and then the court. So it has to travel from all these phases. So the law requires that during all these phases there should not be a tampering. And how do you ensure that? You take a hash value of the footage at the beginning, and you take the hash value of the footage at the end. If both of them match, it is a good proof that it is not tampered. For example, if there is a 1 lakh pages document or 10,000 pages document, and you take a hash value, if you change a single comma in the entire process, then the entire hash value changes. Now, what is a hash value? Hash value is nothing but a string of certain alphabets and numbers, numericals, which is short, may not be more than 30 digits, which in fact, the entire 1000 pages will be reflected in that that string of alphabets and numerals. And if you change a single digit there, this will undergo a change. I'll show you how that really works. And the hash results are very essential part of 65B. For example, you can always give hash values of your data to show to the court that, look here, I have not tampered with the data. This is the hash value when I acquired the electronic evidence. Okay. And this is the hash value today when I'm filing that in the court of law. So there is no tampering. So I'll in fact, I'll show you this. But before that, okay, I'll start with the hash value. See, this is a hash tool which is available to you on any app store. That is not a big deal. The hash tool. Look at here. This is first document. Can you read Yuvraj here? This is YUVRAJ, Yuvraj. This is a sample one. See, this is sample two. I have just added this A here, Yuvraj. Oh, it was YUVRAJ earlier. Now it is YUVARAJ. I have added this A. Now I'll just show you. Let us open the hash tool. Okay. There are multiple kinds of hash. There is MD5, there is SHA1, but the standard one is MD5. I'll select the first one. Can you see the hash value here? Yeah, the hash value is here, 1. Uh, can I ask you something, that is it properly visible, or do you or can anyone respond? Is it fine?
Increase the font.
Okay, I'll maximize the window. I don't think the notepad font I can increase. I'll do that.
Yeah.
Yeah. Okay, I don't know. But anyways, I think this should be visible, right? The Yuvraj, these words. Okay, this is what it is. Okay, so now I just took the example of this. I just uploaded the file called Yuvraj here. Can you see this? This is the called as an hash value 1F31. This is the hash value. Now what I will do, I will take another file, sample2, where I had added the word A in Yuvraj. Look at the hash value here. It is now 5B19DB. A single alphabet has completely led to a change of the hash. Now, if I again go to sample 1, you would see again 1F31. So the first one and the third one will be same, but the second one has undergone a change. Now the file that I'm selecting is called as, is of course a data file, but it can be image file, it can be video file, it can be anything. It can, hash value can be made up of anything. So this was just to show you the demo of this is how the hash values are created. And it will be my advice to all the proponents of electronic evidence that do make sure that if it's possible, go for hash value, give the hash value of your electronic evidence, make it part of your 65B certificate. Now, when it comes to email, two things about email. Uh, I'll show you. See, can you see this email here? It looks like it has come from HDFC, right? Now, always make sure that whenever you are printing an email, go for the raw message. This is called as an email header. You will always find that option. Some Gmail has different option, Yahoo Mail has got different options. It's in Yahoo Mail, it is here, view raw message. And here, now I'm sorry, really, this is very small, in fact difficult for me as well to read, but just to show you, here you will find here somewhere the IP address of the computer. Okay, here. And if you Google this IP address, it will show you from which server this email has come, which part, geographical part this email has come. If it's a proxy server, it's little difficult, but this is really a part of cyber forensics. But always remember, this header will show you the real data of an email. Otherwise, it is very difficult to create a spoof email. What do I mean by spoof? I'll show you. It looks like
Yuvraj, could you
HDFC.
zoom it out so that people can watch it properly, because the size
Uh,
is too small.
okay, let me just maybe
You can just take two lines and then zoom it and then thereafter
I'll,
accordingly.
I'll I'll try to do. I'll try to do. Is it little better now? Is it fine?
Yeah, now better, but the entire line is not forthcoming.
Okay, no. The point I want to only make is
Yeah,
this.
that's visible.
Yeah, that's visible. No? Okay. See, always remember, if you want to look at the real email ID of a person, you have to just hover the mouse over here. And now you will see the real email ID here. Newsletters at clashwick.com. Now, this is by no means coming from HDFC. It looks like HDFC over here, but if you look at here, you would see in the blue letters below newsletters at clashwick.com. Similarly, now I will in fact show you the header also. Since we are now zooming in, look at this. Look here. You will see this. Can you see this X originating IP somewhere here? Here, originating IP. So this is the internet protocol address of the sender's email. Once you get the IP address, any police station or any cyber forensics can immediately get you the geographical location of that sender's email ID. That's not a big deal. In fact, you can also do that with little study. So this is what is the originating IP, where the email originated, right? Now, if you look at here, it will show the domain, the real domain of the sender. Can you see here? Flashwick.com. This is not the HDFC. And this I have taken the real life example from my mailbox. And that is the reason, friends, I was telling you that always make sure that you print the header of the email whenever you want to put that header, the email into the evidence. Again, suppose if you want to put some image in the evidence or some photograph, always again give the metadata of that file. How do you access the metadata? I'll show you. Suppose this is a file, okay, sample. Can you see this file, sample? I do right click, I go to properties. Look, this is called as a metadata. It will show you when the file is created, when it is modified, when it is accessed. So if I want to produce this document in the evidence, this one, I will also print this metadata in properties. It's as simple as that. The advanced forensics experts will tell you, in fact, even this can be tampered, but believe me, this is not really the regular case. So this is taken at its face value, and it is always better. Suppose this is the image. I right click, I go to the properties. This will show me all this. So always make a point to put this along with the 65B. Now I will show you how the images and all they are morphed, and how the people really do the morphing, and how the experts detect it. This is little digressing, but I think in 2 minutes I'll really want you to see that. It's an interesting thing. This is the forensic tool for me to analyze the images. Okay, I'll show you the images first. Okay? There are two images. Can you see this boy here now? There is a boy. Fine. Now, many a times it so happens that there is a tampering with the image, and it will be made like this. The boy is not there. Or a better example, look at this. Can you see this boat or ship? Fine. This is the real image. It will be shown as this, as if it is sinking. How do they do it? I'll show you. What they do is this. They will take the water portions from here. Okay. They will take water portions from here and they will paste it somewhere here in between. And they will make it look like that sinking boat. This is called as a cloning. And how do the forensic experts find it out? I'll show you. These are very basics, but just to give you a taste of it, I'll show you. Now let us upload the first file. This is fine, right? And now we want to see the morphed one. Now let us go for a clone detection. Just wait and you will see that it will find out the portions which are copy pasted, which are not otherwise visible for a naked eye. Look at it. This portion has been taken and this has been pasted somewhere here. So the portions have been copied from here. This is called as a cloning and they have been pasted here. Same if you go to the boy's image, I'll show you. And if I do the clone detection again, the boy was here somewhere. Look. So the portion of the trees is taken from here and it is merged here. And the portion of the land has been taken from it is merged here. So this is known as a clone detection technique. There is also error level analysis, noise analysis, but I think today I should not digress a lot because this is not a topic of a forensics. We are more on the legal aspects of it. So just to tell you friends, this is how the world of cyber forensics works. So make sure that whenever you file into evidence any electronic record, then as far as possible, I'm not saying in every case it's possible, as far as possible, give complete details. If it's a WhatsApp chat, uh, you can give the entire details. You can, there is a, on the WhatsApp right hand side, you will see there is a right column where you can archive all the messages and you can mail it to yourself. It's better that you produce that in the evidence rather than taking the snapshots and producing that in the evidence. So in every case, you can try to make it better and better. So it is not impeached in the course of the trial. So with this, uh, I think I am done, Mr. Vikas. I think it's always important to be little creative when you are dealing with electronic evidence. And this topic is really, really very vast. But I believe that if you are little cautious of the nitty-gritties of this, then as a lawyer to disprove it, suppose you take a hash value, you insist for a hash value from an expert. If you're cross-examining an expert, you can ask him, where are the hash values when you acquired the evidence? Can you compare those hash values with the hash values of the public prosecutor? He may say no. Then I think that's a good benefit of doubt that you should get for an accused. So these are the best practices you should follow. That may be email header. You can ask the person that where is the email header? Why did you not produce it? If you have not produced it, though you had it, why shouldn't an adverse inference be drawn under section 114G of the Evidence Act? You withheld the best evidence. So I think with the help of a cross-examination, with the help of going into the details of 65B certificate, I think certainly we can not only prove, but I think what is more important, we can disprove the electronic evidence. Thank you. Thanks a lot.
Yeah. The way you simplified the things, that was quite amazing.
Thank you.
Just like your namesake, I'm just reminded when Stuart Broad was hit for 6 sixes by Yuvraj Singh. The ease with which he hit the sixes, the ease with that, the same manner you explained the electronic evidence. And you rightly said that this is a new aspect you understood. And those who want to get themselves unmuted, but then they will have to come on the video for asking the questions.
And
And
yes,
those
I
who
will
want to
be
actually,
sending the citations to Vikash ji, who will
I, Mr.
circulate them.
Yuvraj, I
So
have shared it on the WhatsApp group. They can send a ping on our mobile number.
great, great,
They
sure,
can
sure.
join our WhatsApp group.
Yeah,
Then they can come to know the judgments.
sure,
And that will
sure.
be shared only today. Let's assume somebody says after a month, kindly share it. It will not be done. Uh,
Yes.
yeah, this is why the court needs to consider the hash tool generated report, which might be the tool made out of India, to consider it as a forensic evidence without even considering the CCTV footage, which has recorded in India that can be analyzed by an engineer.
No, sorry, I think
It's a quite big question
which might
by
be
Abhishek
the tool
because he's a combo engineer plus an advocate. Therefore,
No, see, frankly, no, no. The question seems to be why do we really need to go for the hash tool which is generated outside India to consider the evidence which is within India? No, let me tell you, the cyber evidence or the cyber world is is such a field of law which really knows no boundaries. Now, if there are better tools available, and I must tell you, in fact, the forensic analysis and forensic
YouTube वाला भी भेज
investigation
दे link.
are
YouTube वाला
so
link चला.
well developed in other countries, and where in fact I had a chance to visit for the project that I was in fact I'm in the process of writing a book on this topic. So I had to travel and I had to visit and I had to collect the resources. Let me tell you, the resources that these people have got with themselves are amazing. Unfortunately, in India, we are still lacking it, and therefore I don't see there is any harm of taking help of something that is generated outside India to make sure that whatever you are submitting is true and authentic.
Yeah.
And let me also address one more portion. In fact, I missed it. See, the electronic evidence, when you get a mirror copy, you can always send it to your own analyzer, your own cyber forensic expert for getting evidence in your favor. Or in your favor, I mean that evidence as your version. Now that person has to be notified, okay, under section 79A. Otherwise, it is not to be held as a valid evidence, because if you look at section 45A, whenever you want to get an electronic expert, that lab has to be notified under section 79A. Otherwise, that evidence technically does not carry any value. There are people who also argue that why not section 45 also talks of science, so it can be admissible through section 45 or 293 of CRPC. But technically speaking, the expert has to be notified under 79A. There were very few experts notified, but I think now they have started notifying so many laboratories. Yes.
Yeah. I'm just checking because on this group we don't have. I'll check it out as to whether we have on the YouTube.
Yes.
Uh, when can the uh, mobile बंद करो. When can the accused adduce electronic evidence like email, and how is it a defense? How is it at his defense stage or before or how and how?
No, sorry. Can you come again? Sorry, there was some
He,
disturbance.
he says when can an accused adduce electronic evidence like email, and how is it to be used in the defense stage, before or after?
No, before or after of what?
That question is
No, see, I'll tell you. In fact, if the defense has to produce any evidence, of course, there are summons trials, there are warrant trials. We have from 239 onwards. Then you have sessions from 225, 251. You have the summary trials. So the stage differs when the defense has to produce the evidence. But uh, yes, the defense can very well put in his evidence. Uh, Generally, the defense will be the best benefited by the Section 207. He is entitled to the copy of the entire charge sheet, and as I said, Justice Muralidhar has said, the mirror copy. So the instead of getting his own evidence, he can utilize the evidence which is being given by the prosecution to decode it and dissect it and show that it is not reliable one. Of course, he can get his own piece of evidence. The law, of course, entitles him to do it. But the
before
stage
I
would
take
differ
the next
depending on the
question.
trial. Yeah,
Yeah,
sorry. Yeah.
before I take the next question, everybody's writing ad. We won't add. You just send a ping on the WhatsApp number. We will add you thereafter. This is by Webhub on YouTube itself. In Section 138 Negotiable Instrument Act, when can an accused adduce electronic evidence like email, and how it is to be used in the defense stage?
No, I think the whenever the stage for filing of his defense comes, he can file that along with his defense, and the 65B certificate would be required. only when that evidence is to be admitted and marked as an exhibit. So as I told you, the stage for adducing of the evidence would differ as depending on the trial. It's a summons, sessions, summary, or whatever. But the procedure remains the same, irrespective of civil or criminal. That you can file it when your evidence begins, but uh, you have to file 65B as and when you want to get it marked as an exhibit. And let me tell you, suppose in a cross examination you are aware that you can confront a witness with something under section 145, 137 of evidence act with his previous statement, to contradict him. If the courts have gone to an extent of saying, I'll also share that citation, that if in a cross examination, if you want to show some email to him or some electronic record, you can't do that unless you have 65B along with that. So you can't even show something to the witness, to contradict him or to refresh his memory unless you have 65B. So the procedure remains the same. Whenever you want to get that into evidence, please get 65B and get it done.
Yeah.
Yeah.
On YouTube, we don't have. I will just check it out as to whether we have on the Facebook.
Yes.
No.
Yes.
So thank you, Mr. Yuvraj. Just one question they have come.
Yes.
If I have used a computer and then I have returned the computer after using for a year, now I want to produce some documents which I had while I was using the computer. I have copied that in a pen drive while returning. Now, who has to give that certificate?
You have to. The person, because see, if you look at condition A and condition B of 65B2, it says the relevant point of time during the relevant period. Now, this relevant period for you will be that 1 year when the computer was lying with you. Okay. So for that computer also, you have to give the certificate. And again, you are the person who has got it to in pen drive. So again, you have made the transfer. Again, you are the person who has to give the 65B. Though that person, see, it is not the 65B does not require that the owner has to give. The person who is in a management of the device, that you, it was in your management. So irrespective of the ownership, it is the person who has to, it's you who has to give it.
Yeah.
Yeah, it is possible to submit a computer as evidence. Why not? In fact, Justice Nariman says it, that computer can be tendered into evidence and then that will be a primary evidence. But frankly, let me tell you, I think soon we will have to revisit this proposition of Arjun Pandit Rao. I personally believe there is nothing primary and secondary in the world of electronic evidence. Everything is secondary. Okay. Because the computer understands the binary language 01001, and that is a primary, which we can't read. So it has to be a secondary if we want to read it. So whatever you see on the screen, it is always a secondary. So I personally believe that there is nothing as a original and secondary. Though Arjun Pandit Rao does say that original does not require 65B. For example, even if I'm typing out something, you all are aware, if the light goes off, when you restart the computer, you will still have that draft. Why? Because it is copied on a cache memory. It's there on a RAM. So there are already copies made, So where is which one is the original one? There are no originals and secondaries in this world. But anyways, we probably will have to wait for some another judgment to get a clarification.
So, Mr. Yuvraj, the session was quite fascinating, and I am quite sure that a lot of people would learn from it and will continue to learn subsequently, since we are already live on the YouTube as well as Facebook. Those who have missed it from some part, they can always watch it on the YouTube. And before we part for the day, tomorrow, friends, we will be having on the new Industrial Relations Act and Industrial Code 2020 by Mr. S.N. Murthy. We had already one session with him, but on popular demand, the same topic we are coming across. So do stay connected with us. And they are saying we should have a session with Yuvraj. We can always request him. He has been kind enough to accede to our request.
Sure.
And this time, before we part, I will request Yuvraj to make a request for social distancing and wearing masks, and
Sure,
because
sure.
that's also paramount. Because once there is health, then only one can learn the knowledge.
Absolutely. No, I would in fact say this, that of course wear the masks, maintain the social distancing, but in fact I'll say something more, that whoever of you are suffering from any physical ailments, their near and dear ones are suffering, I pray to the Lord that let force be with them and they will be cured. May all of you live a very long healthy life, and whatever possible, maybe financially with your own efforts, let's little go out of comfort zone and help others around us. I think this is the time when I think we are all the human beings first and then respective professionals. I think let's go really out of the way to help the people around us. Let's do it, and it can be a minuscule help, but please do it, and that will matter in the times to come. Please do that.
Yeah.
Yeah.
I'm just reminded that when I was just listening to Mr. Rahul Dravid's interview, he used a famous quote. He said that when he was not getting a break, I'm not saying the professional break or this, it said that he wrote on his kinetic Honda that God's delay is not God's denial. So he says, keep on believing yourself. So that's what we can do.
Right.
Thank you, everyone. Everyone
Thank
stay
you.
safe, stay blessed,
Thank
and
you.
do stay connected with us tomorrow for the session. Thank you.